My name's Edward Rubin. I'm a law professor, and for the past 4.5 years have served as the dean at Vanderbilt Law School. And I came to Vanderbilt because I was interested in working with the faculty on ways of rethinking legal education for the 21st century. The problem with legal education, as it exists now in the United States, is that it was developed immediately following the Civil War by a New York lawyer named C.C. Langdell at Harvard. The program that he developed was a very forward-looking one at the time, and one that represented the most advanced legal thinking, but there have been a few developments in the intervening century and a half since he developed that program, and it's now seriously out of date. One of the problems with the Langdellian curriculum, as it's known, is that it's very heavily litigation-oriented. And in a time when we're trying to move toward different conceptions of law and different roles of the lawyer, to be stuck with something that has such an adversarial and litigation orientation represents a misrepresentation of law as it exists in current times, and I think a less than complete way of educating students. So why? Why did he develop this adversarial litigation-oriented curriculum? Well, the Langdellian curriculum was really the first time that law had been fully accepted on a university campus. And Langdell's basic problem, the basic issue that he was trying to solve, was how to justify law as a discipline worthy of university study as opposed to a trade school or apprenticeship type program. There had been law programs on university campuses prior to the Civil War, but they were essentially renting space. It was almost like a scuba diving school that rented space at a modern university gymnasium to carry on their scuba diving lessons. In other words, it wasn't regarded as something worthy of college credit or of being an intellectual discipline on a university campus. Langdell, working together with the president of Harvard, Charles Eliot, changed all that. But the way he changed it is to argue that law was a science and that it followed certain rules or regularities that could be discerned by interrogating the students about the primary source material, legal cases, and that's the origin of the famous Socratic method. Now again, Langdell isn't to be blamed for this. It sounds very much out of date, but you have to remember, at the time that he was developing this at Harvard in the 1870s, there was no social science in the United States. Empirical social science doesn't come in until the 1880s or the 1890s. The first economist, real economist in the modern sense, was Charles Dunbar at Harvard in the 1880s. The first political scientist was probably Woodrow Wilson, which was also in the 1880s. So Langdell, looking around for some analogy, some way of validating the study of law, came up with the idea of natural science and the idea that what he was going to do is have the students study primary source material and discern the underlying regularities. Now, some people say that he was influenced by Darwin and that he had an evolutionary theory of law. I'm pretty sure that's not true. I don't think he knew anything about Darwin. He wasn't really intellectual enough to have kept up to date with current developments in biology. The person he did know about was Louis Agassiz. Louis Agassiz was at Harvard, and he was an academic superstar, probably the most famous university teacher at the time. Women used to swoon as he passed by. And Agassiz believed that biology could be studied empirically. And in fact, what he would do is have students hold a grasshopper when he taught invertebrate biology and look at the grasshopper as he talked about the various details of invertebrate morphology. His theory was that if you looked at nature, you would discern underlying regularities. And these underlying regularities were fixed. They were unchanging. They were not evolutionary. In fact, he turned out to be an opponent of Charles Darwin. He believed in special creation and ultimately wrecked his academic reputation trying to defend that increasingly implausible position. When Langdell arrived at Harvard, he was essentially using the same model, that you would discern these underlying regularities that were built into the English common law, and that from that process you would understand the principles that guided law. We no longer believe that you can do that, but we're still stuck with an educational system that has that as its premise. So for Langdell, litigation and the rules generated by courts were the only thing worth studying, because those court decisions would reveal to the students these underlying regularities that made law like a science. So what's changed? Well, one thing that's changed is the advent of the regulatory state. And regulatory legislation responds directly to political initiatives. It does not have the underlying logic or coherence that you would find in judicially developed rules of the sort that we have in our common law system. And so as soon as you start looking at regulation and statutes, you have to abandon that notion, and you have to look at how these statutes work in their actual operation. You can't just look at how they're litigated, you have to look at how they're designed and what their purpose is in regulating human society. We still don't regard statutes as being central to a student's legal education, even though everyone recognizes that our legal system is now dominated by statutory law. And in fact, statutory law has displaced common law across a wide variety of areas. So that law students, when they come into law school, are still given a steady diet of common law courses and are not introduced in a general matter to regulatory law at all, and not introduced to the specific of regulatory law until they choose various upper class electives. One of the things that we've done here is to introduce a course on regulatory law as a basic course that's taught in the first year alongside of the common law courses. A general introduction to the regulatory state that we can use for students to give them a sense that regulatory law is central to modern law. In fact, in many ways, more central than the common law courses that constitute the entirety of their education in a traditional legal education. Now, again, this is not, therefore, a primarily litigation-oriented course. It's a course on how to write statutes, how to read statutes, how to understand them, how to follow them, how to vary them or find loopholes in them if the client feels that they're oppressive and they are interfering with the client's business, when that's permissible and when that's not permissible. So it's an entirely different approach. One of the points we make to the students is, if your only reaction to a problem that your client has with a regulatory statute is to sue the regulator, you're not a very good modern lawyer and you're not doing a good job.